Good morning, Mr. Fair.
Good morning, my lady. Having reflected overnight, and unless any questions have arisen in the meantime, I propose to address the court on essentially 7 points in reply to what I heard yesterday from my learned friend. You have my skeleton argument. I'm not going to trawl through it in great detail. That is the answer to HMRC's skeleton. So, for the purposes of today, the first point I want to address the court on is the test. Because ultimately, there's an error of law if the tribunal didn't apply the right test. And we say the test is quite simple. It's essentially reciprocity. Is this payment or other consideration given for that supply or that group of suppliers? And whilst the Court of Justice and other courts put that point in different ways in different cases, we say it all comes down to essentially a theme of reciprocity. So if you have, for example, the stipulation of a price, and that shows a reciprocity between the price and the supply. In Zlakov, we saw at paragraph 33 yesterday a reference to effective consideration. Is this effective consideration for that supply? That's another way of putting the point. In Jamina L, we saw the court talking about, well, are these mutually linked? Or would this activity have been envisaged without the funding? That was at paragraph 38 of Jamina L, which we saw yesterday. And so what these cases demonstrate is that there's a range of links that can be described in various different ways, but they all have this common theme of reciprocity as one given for the other. And to emphasize that point, if I could show you briefly, please, the Supreme Court in Airtours.
Well, just before you go on,
yes.
I understand the point you make, but what is your submission as to the relationship between reciprocity and direct link? Are they synonyms, or is one an explanation of the other, or what?
If there is the relevant reciprocity, then generally, something surprising aside, you will have a direct link, and that's what I intend to show you in Airtours.
Well, okay, I think my question was badly phrased. I think what I meant to ask was, are they 2 tests or one? In other words, if you have a direct link, does that give you reciprocity, or do you need to establish both?
No, I think reciprocity is the explanation of what direct link means. And we saw, if you remember, when we went through Wakefield, that you can have a spectrum of directness, and a link may be strong enough to amount to consideration, but not strong enough to give rise to remuneration in the economic activity sense. So in my submission, when I refer to reciprocity, I'm trying to explain what, when you look at these cases and the various facts they consider and what they accept as amounting to a direct link, which of itself doesn't tell you very much, the essential concept they seem to be coming back to is reciprocity. That's why we saw in Jamina L mutually linked. We saw, well, would this activity have been envisaged without the funding? Or the idea of effective consideration, or even stipulation of a price. It's all trying to get it, is this for that? Which given that the statutory test is actually consideration for the supply, is not particularly surprising. It's is this for that?
And so you're saying that reciprocity explains what you say is a spectrum of what may be sufficient to be direct link.
Yes, if you've got reciprocity, then I would generally expect that you've got a direct link. I'm not going to say always, in case somebody can come up with some example which I hadn't considered, but reciprocity, that's my explanation of what you see in these cases. And I'm going to show you now, if I may, the Supreme Court in Airtours, and that's at tab 7 in your authorities bundle, page 81. The facts of this case were that Airtours had paid for the provision of professional services by PwC as part of a financial rescue plan, and essentially it was the banks and the creditors who needed and wanted this financial report from PwC, but Airtours was saying, well, we're the recipient of the supply, even though even though the banks want the report, we're the recipient of the supply, so we can recover the input tax. And so the question was, did PwC as the professionals make a supply to the banks alone, or did they also make a supply to air tours such that air tours could recover? And the answer was the supply was solely to the creditors. If we could go please to page 94. And at paragraph 48, we see the courts explaining the same approach adopted by the Court of Justice in loyalty management, where they stated, citing previous judgments, that consideration of economic realities is a fundamental criterion for the application of the common system of VAT, and added that the issue involved consideration of the nature of the transactions carried out in that particular case. To much the same effect in Tolsma, the Court of Justice said that a supply of services is effected for consideration only if there's a legal relationship between the provider of the service and the recipient, pursuant to which there is reciprocal performance, which are explained as meaning the remuneration received by the provider of the service constituting the value actually given in return for the service supplied to the recipient. So there you see, what does direct link mean? Well, it's getting at reciprocity, it's getting at whether one's given actually in return for the other.
That's in a two-party scenario, isn't it?
Yes, I'm going to show you in a moment what they say about the three-party scenario. It goes on to make the same point in relation to Primbach. It says, in the context of the supply of goods, the court made the same point in Primbach, where it described the determining factor as the existence of an agreement between the parties for reciprocal performance, the payment received by the other one being the real and effective counter value for the goods furnished to the other. So direct link on its own doesn't tell you a great deal about what is or is not a direct link. But the idea of reciprocity helps us, I think, understand a bit more what we're getting at here. And my submission is consistent with each of the cases we have been through. As my lord said, that there is the question of third-party consideration. If we go forward, please, to page 96, because having not succeeded in persuading the court that there was a supply to air tours, the air tours said, well, the effect of that must be then the supply was not for consideration at all. But that didn't find favour. If we please read, we begin on page 95, paragraph 54, and if please could I just ask you to read 54 through to 58 to see the answer to that particular point.
Thank you.
You see in particular at paragraph 57, the Supreme Court picking up the reciprocal performance idea and saying, well, in this case, in a three-party case, you look at it from the perspective of the supplier. So from the perspective of the supplier, is that consideration given for that or those supplies? The same point can actually be seen in Wakefield, we did look at certain paragraphs yesterday. If I could just show you two more, please. If we go, please, tab 8, paragraph, page 110, please. And in paragraph 15, we see 2 points there. First, again, that reference to, well, is it given in return for the supplies? And second of all, how it's calculated actually doesn't matter. As I said in my skeleton, I'll come back to, the only way in which the way it's calculated might matter is if it suggests it's for something other than the supply of services. The other paragraph making similar points is paragraph 52, page 118. Again, you see the in return for the reciprocal performance point. Again, there's no need for the consideration to be any particular value. In terms of you've seen many references to legal relations, but I don't think HMRC are particularly relying on that point, but I dealt with that yesterday.
Well, I think they do draw a distinction, don't they, between this case and the right of residence in rayon d'or against the insurance fund.
Yes.
To have their costs paid.
I think he put it, it's a helpful factor to Mr. Mantle, but not an essential
not
factor, is the way I understood it. Yeah. And I showed you yesterday in Jamina L, there was no, paragraph 38, they said there's no relationship between the funder of the asbestos removal and the residents who benefit from the removal of the asbestos, which shows it's not a requirement. In that case, the funding was provided to the municipality who arranged the asbestos removal, and that was third-party consideration for the asbestos removal, even though there was no relationship between the funder and the residents. So we say it's not a requirement in terms of there being a relationship between the two funders and the recipient of the service. Just before I leave the first point, the question of the test, as I said in my skeleton argument, and we maintain, a supply for consideration and funding on conditions are not mutually exclusive. Funding on conditions can very well involve consideration for supplies. It just depends on the facts. So it's not helpful to try and just set up a dichotomy between this must either be funding on conditions.
Isn't that what the Upper Tribunal did?
It said we have two diametrically opposed analyses in terms of South Africa and rayon, and then proceeded to say this is more a rayon case. And I agree this is a rayon case. I'm not sure the Upper Tribunal was saying funding on conditions can never be consideration for supply, and I don't think even South Africa was saying that. I'm going to look at South Africa, albeit briefly, later. But, well, even if the Upper Tribunal did say that, my submission remains that they're not mutually exclusive. Having identified the test, the question then for this court ought to be whether these tribunals in 2024 and by extension the Upper Tribunal in 2020 asked themselves the right question, because if they did, then it's difficult to see where the error of law is. If we please go to the Authorities Bundle 201 to look at the Upper Tribunal 2020. I'm going to come back to the Kenema rayon point, albeit in my 7th submission, because general proposition doesn't matter. but I will come back to it. I'm not ignoring it. But what we say is highly relevant, given what the test is that the Upper Tribunal, in our submission, applied exactly that test at paragraph 74 onwards. And really, my learned friend needs to identify an error of law in these passages, because otherwise, overall, the decision is correct. And we see at the end of 74, the Upper Tribunal says, we're now going to consider this so-called balance sheet approach. And we address the arguments, although not necessarily in the order they were taken. First, statutory background. We've seen they said that's neutral. Not sure in the end Mr. Mantle disagreed with that. 76, the FTT found that the existence of agreements between the funding agencies and CIC was a neutral factor. Their existence was consistent with either side's case. The fact that there were agreements might be said to be consistent with either party's case, but the content of those agreements is far from neutral, because the agreements are the starting point in the analysis. We do not consider them to be evidentially neutral, rather we consider them to be key to the analysis. There are 4 important features which provide the answer to the question. I should have shown you, whilst we were there actually, in Air Tours, it was paragraph 47, which makes essentially this point that you start with the agreements. So before we jump on, just to show you that approach is correct, and apologies for moving you around, on page 93 of your bundle in tab 7, at the bottom you have paragraph 47. Just to show you that that is the correct approach. Apologies for jumping around. Back to page 201. So we know so far this is the right area to be in, looking at the contracts and seeing what they tell us about the relationship. And at 77, this is the first of the 4 points. Although the agreement did not state in terms which courses CIC was to provide, they did restrict the funding to the courses within a list on the government's website. The essence was that the funding was for those courses. CIC was not at liberty to do anything else with the money. Second, the amount paid was by way of formula and not negotiated. There was some room for negotiation if larger student numbers were anticipated for some reason, but that did not arise in the periods considered. And that anyway was an exception to the general rule. The use of the formula is not itself a basis for concluding the payments are not consideration, as Roundel shows, but in this case the components of that formula give clues as to what the grant of payments were for. And just pausing there, we note in both 77 and 78, the Upper Tribunal is correctly asking itself, well, what are these payments for? And then in order to answer that question, it's correctly saying, well, let's look at the arrangements, what they tell us about it. And it's saying, it goes on, the starting point was a per student amount. The number of students was based on the last year's intake, used as a proxy, the expected number of students in the current year. There were a number of adjustments to be made, which related to the courses themselves, mostly reflecting the higher costs of providing the courses to the students. The formula was therefore highly specific to CIC's outputs, to the number of students, the type of students, the number of courses, and the type of courses. And that's entirely correct. I mean, I think the only objection Mr. Mantle takes to that, I think, is, well, the number of students was based on expected number, which was based on last year's number rather than actual number.
I'm just wondering about that. I mean, if the funding agencies had said, we will pay you £1 million for you to provide approved courses for free to every eligible student who secures a place to do that, might say, well, that's the price, and the number that receive it may vary. And instead, they've been a bit more granular than that, and they have at least tried to find something that approximates to the number of students.
Yes, they've tried to, and we're going to. My next step is having said that I think the Upper Tribunal's right, is to show you the agreements in a little bit more detail. But yes, they've gone to the effort of trying to make this price, this money, very closely match the outputs, and it may or may not in the end get exactly the right, but it's close. And if as I said yesterday, if it can't be right that if you use expected consumption as the basis for a price rather than actual consumption, somehow you fall outside of VAT. That would be a recipe for avoidance on an enormous scale. And that we've seen, and we're going to see, the way you calculate the price is not relevant to whether it's for consideration, whether there's a direct link, save insofar as it says it's not actually for that, it's for something else. And an example, I'm going to come to it later, of where the formula actually did show us for something else is the PSA case. Because in that case, the amount received by the transporter was inversely linked to the amount of transport it provided, because it was designed to make up losses. So if they had a good year and lots of people used the transport, paying for the transport, they needed less by way of compensation at the end of the year. And whereas if it was a bad year, then they would get more. So actually the compensation was inversely linked to the use. So there the formula did tell you something, and in the opposite direction. But here, the formula, I can't see how you can argue it's against me, but as the Upper Tribunal says, it's actually strongly in favour of it being consideration, because it's so closely matched to the outputs.
And in one case, I think it's SFA, you've got the clawback.
You've got the clawback, and you've also got, as the Upper Tribunal even says in 78, and I'll show you this in the contracts and the documents, if there was expected to be a significant deviation from the predicted figure, let's say a new campus was opened, then the parties would adjust it, because that's what they're trying to do here. They are trying to give remuneration, consideration for the supplies actually to be provided. The lag number is just the best starting point, and in most cases it may be the end point. But as it's said there, there is room for negotiation if it's not going to accurately map onto expected use for this year. So what is that number used for? It's a proxy for expected actual use, which as I said, must be sufficient to link a price or a payment to the suppliers.
And it's a practical mechanism, given that perhaps the grant procedure doesn't necessarily follow the academic year.
Well, no, it doesn't, and the witness statement explains this. The procedure starts several months in advance because you expect. They have to plan. They have to plan in terms of what teaching staff and other resources they're going to have. So they need some idea as to what resources they expect to have available. So it does start much earlier in the year, and that's why it has to be based on some sort of estimate. Otherwise, you wouldn't be able to do that planning. But then it does get adjusted if needs be, and there's clawback in relation to SFA and even in relation to EFA. If the numbers significantly differ in year, there can be negotiations up, and there can be demands from the EFA. I'll show you that shortly. But in terms of the basic question, given that the actual amount doesn't matter, save insofar as it tells us what it's for, none of this suggests it's for anything other than provision of those courses to those students. The clawback is then discussed by the Upper Tribunal in 79, and again, we agree. This is not about later year adjustments to early year VAT. It's all about telling us what are these payments actually objectively intended to be for. The fact that they are liable to end of year adjustments, or that there may be some adjustment in the later year to reflect it, tells us again it's all linked to outputs, it's linked to use.
So at one point Mr. Mantle seemed to suggest that there could be a difference between clawback and retention, because clawback was in year and retention was the following year. And I'm not sure he nailed his colours to the mast on this, but he certainly floated the possibility that that could lead to different conclusions. regarding EFA versus SFA, because one was clawback and the other was retention. And just to finish, I think what he was saying was that even if we were against him on EFA, we shouldn't be against him on SFA, if I've got them the right way round, because maybe it's the other way around, but anyway, whichever way round it is. The one where it's retention, his submission was that clearly can't be right, because the adjustment is the following year and you're concentrating on the tax year in question.
And my answer to that is the same one I put in my skeleton. These adjustment mechanisms are not, it's not because we're trying to adjust the VAT, it's just further evidence of what the actual payments already made are for. And we've started from a very strong starting point of having a formula which closely links it to actual use. And even if there was no adjustment, it wouldn't matter, because it's still a payment that's calculated and therefore objectively appears to be for those supplies. The relevance of the adjustments is simply it confirms that.
And the existence of the adjustments can't make your position worse.
No, my position would be exactly the same even if there were no adjustments. Because you'd still have a lump sum paid for the education for those individuals. It just, you'd end up in exactly the same place. But as we saw at 78, there can be in-year adjustments, and we'll see it in the documents for exceptional underperformance. For example, it cannot be right, and it isn't right, that if Colchester was given money to fund 2,000 students and ended up funding 10 in a year, there would be no consequence to that until the following year. And that can't be right, and it isn't right. I'll show you that. So, again, it's just all these are factors that we're taking into account to answer the basic question is whether the payment's actually made, irrespective of any adjustments, or for the education. And you'll see at the end of 79 that the first tier tribunal and the upper tribunal in the earlier litigation didn't distinguish the two methods of adjustment. Saw no meaningful distinction between them. And that's right in terms of what they tell us about what their actual payments are for. Paragraph 80 points to the fact that information is provided, allows the CIC to monitor and adjust their payments to match the data. You see that by E, according to the standard formula. And so the question is, did the upper tribunal ask itself and answer the right test? And we say, well, clearly it did. It was asking, were these payments, the actual payments, not payments following an adjustment or anything like that, but the actual payments made, were they for the education supplied to those individuals? That was the question asked. That was a correct question, and it was answered in the correct way by looking at the arrangements and seeing what they told you about it, what it was for. So when I try to work out what HMRC say the error of law is in this part of the analysis, it seemed to be a general statement that the upper tribunal lost sight of the need for reciprocity between a payment and a specific supplies. The point seemed to be, and I'm going to come back to this later, that, well, you had a lump sum for supplies to multiple individuals, and therefore it couldn't be consideration. And the same point seemed to be put in a different way with this stipulation of a price point. Well, I'll deal with those points again later, but if those points are not correctly made, or sort of don't amount to legal principles that need to be applied in every case, then I don't think HMRC have identified an error of law here. In my submission, those aren't points that rise to the level of general principle or points that have to be applied in every case. You can look at it a different way, as I did at the beginning yesterday, which is say, well, hang on a minute. Money's being paid. On the face of it, it looks like it's for that education. what else is it being paid for? We had suggestions yesterday of some sort of general funding of Colchester's educational activities, but that can't be right, because we saw that the power is to fund eligible students. It's not a power to fund non-eligible students. And it doesn't even look like that's happening. This is not a generalised fund for U Colchester to supply educational activities. It's quite clearly linked to the specific students who are eligible and trying to provide a payment that is linked to that particular output. So not only is it quite clearly for that, it's not really anything else it could be for. Moving to my third area, I was going to show you, if I may, some terms of the agreement. Just you've already seen what the Upper Tribunal said. I say that's correct. I can emphasise that, if I may, by showing you certain parts of the agreement. Pick up the supplemental bundle, please. And behind tab 5, we should have the EFA agreement. And if we go to page 20, please, we see the beginning of part 2. Part 1 contains some general statements. Part 2 is where the more specific terms are set out. And we see in clause 2, college's obligations, 2.1, the college shall provide the services, shall allocate sufficient resources to the services to enable it to comply with the EFA conditions of funding. Services is a defined term. If we go forward, please, to page 44. You see there in the definitions, services means the services to be supplied by the college as set out in the funding agreement, the college's obligation under this funding agreement, the conditions of funding. And below that, we see the definition of student. Student means any person to whom the college is required to deliver any of the services. This term may be used interchangeably with the term learner in this condition of funding.
No, that's defined on the previous page
It
in
is.
exactly the same way, isn't it?
Exactly. I don't
Required
know why they
to
decided
deliver.
to have two words for the same point, but yes. And so we see that this agreement envisages that services are being supplied to the students, and in fact that's the obligation of the college, to provide the services. Who is it providing them to? Well, at the very least it's providing them to the students. If we could return, please, to page 20. Clause 2.2 is an obligation to perform the services with reasonable skill, care and diligence in accordance with the conditions. Clause 3.1, the college shall deliver each of the learning programs as set out in accordance with the terms and the conditions of this funding. The detailed requirements in respect of each learning program are set out in the conditions of funding as amended. 3.2, the maximum value for a learning program must not be exceeded for any reason except by way of a revision made in accordance with Part 2, Clause 19. EFA will not be liable to make any payment to the college where such payment will result in a total aggregate of payments made in respect of the relevant learning program exceeding the maximum value. 3.3, college is not permitted to veer and move funding between learning programs except by way of revision. 3.4, college must use the funding solely for the purpose of delivering the services. What are the services? What are the obligations under the agreement? The students are recipients of those services. 4.1, in consideration of the college's performance of its obligations as set out in the EFA conditions of funding. That could hardly be clearer. In consideration of your performance of your obligations as set out, the EFA shall pay to the college the funds set out in Appendix 1, otherwise specified. Clause 4.2, the payments will be made by backs and will be made on or before 20th of each month. We do actually have some remittance advices in the bundle to show you that these payments were it wasn't a single lump sum made at the beginning of the year, it was actually a monthly sum. And we can see that if we go, please, to page 167. This is the remittance advice of Colchester in April 2016 from the EFA. You can see there 2.6 odd million for April. Over the page is May. Over the page again is June. And there's about 18 million in total, I think. So this, you can see this is the proportion of the funding is paid each month. That's what's happening here. Whilst we're here, we may as well see that the SFA was operating in a similar way, because on page 170 we've got a remittance advice from the SFA. This one's in May 2016. You can see it's 688,000. There's then a further one for May on the next page, which is 43,000. But then on 172 we move to June, and we have 568,000. And then July is on page 174. These are monthly sums that are coming in. Returning, if we made to the EFA agreement, I think it's page 21 we were on. Just looked at clause 4.2. Clause 4.4 tells us that the overriding principle shall be that lagged funding shall apply other than in exceptional circumstances described in the funding guidance. So that's what I was saying a moment ago, that yes, the starting point is we're going to base it on the lagged funding, the previous year students. But in exceptional circumstances, let's say the opening of a campus or some sort of very significant increase or reduction, it's going to be on a lag basis, and that's entirely sensible. It's a sensible way of dealing with this in the circumstances of this college and the way it needs to plan in advance to know what resources it can take on to deliver education the following year. But what we say is clear is that this is being used as an estimate of actual delivery. And in fact, if we go to the field guide, it adds a bit more flesh to what's going on here. That's page 147. So this is the EFA field guide. And 147 starts by saying, student numbers. We measure the learning delivered by your organisation by counting the number of students, looking at the programme sizes rather than total numbers of qualifications per student. We start by calculating your lag student numbers to decide how many students should be included in your, in this case, 16-17 funding. The data sources we use in calculating 16-17 funding are detailed below. And for FECs, top row, starting point is the number of valid students with a census date of 1st November 15. And given this is for 16-17, that's the previous year. This is then multiplied by the ratio of 1st November, etc. And then at the last four lines, where there is a significant increase or decrease in student numbers, we may revise the allocation accordingly. This could result in a delay to issuing allocations. So why is lag numbers being used? Well, because it's a sensible starting point for estimating actual consumption, actual use in the current year. Is it a hard rule? No, it's not. as we said, and as the tribunal said, that there is a clear effort to closely allocate not just the number of students, but number of hours to students. And we see that over the page at 148, where they band the students into different bands based on the number of hours timetabled for that particular type of student. So it says we fund at different rates depending on the size of the program your students are studying, and in some cases their age and high need status. Categories are, so on. This is not just specific to trying to estimate the number of students, it's trying to estimate the number of hours in total that will be provided to students. 149 is the retention factor, and then 150 is the program cost weighting. This part of the funding formula reflects the fact that some courses are more expensive to teach than others. And then there's a calculation on page 151. Try and estimate total planned hours. But again, all this is doing, you started with, yes, it's lagged numbers, but that's because that's the simplest way of operating this, and we can adjust it, and we will adjust it if there's a significant variation in that. And not only are we going to try and estimate it with the formula estimate the number of students, we're going to try and estimate the number of hours to very closely approximate the payments we're giving to the number of hours of education you are expected to deliver. Return please to the EFA agreement. There's not much else I need to show you. Clause 5 on page 23, quality assurance. College represents, warrants and undertakes that it has the necessary resources and skills to carry out the college's obligations. 7, page 24, the EFA may at any time during the term undertake an assessment of the quality and delivery of the services. One of the services are the services being supplied to the students, or at least includes that. And we've seen, what we can see now, 11.1 is the obligation to provide data on each individual student. That's on page 30. 11.1, the college must supply to the SFA data on each individual student in accordance with the data collection framework. My point on that is when you consider what is the money being provided for? Is it being provided for those specific supplies of education to those specific students in that specific year? The answer we say is quite clearly yes. We see the same point in the SFA funding rules, which begin on page 51.
But before you turn to that, back on page 22, you've got a mechanism at 4.5 and 4.6 to recover items which have been paid over in error as a result, discovered on an audit, but as a result of errors in the way that the system has been applied. And so presumably that is going back to the formula and to make sure that the formula has been applied in relation to the students in question.
Yes, I think that's right. And as we've seen, that the EFA has the power to adjust to actual numbers. So if they agree based on 2,000 students, and then the monthly data starts coming in, and there's 100 students, then they have.
And they do their audit.
Yes.
Yeah. Then they can recoup.
Yes, because and as we've seen, they recoup from later payments as well in the same year. So yes, I agree.
I'm sorry, you were taking us on.
Moving to the SFA funding rules, that's at page 51. And we can seeing definitions, clause 2.1, definition of a learner. Learner means any third party, including any student, apprentice, trainee or similar, to whom the college is required to deliver as a provision. And provision is defined lower on the page. It means the education and training to be delivered by the college under this financial memorandum. So there's, again, it clearly envisages specific education being provided to specific people. And that being the point of this agreement. Clause 5, we have the provision of information again, and then clause 6 on page 53, funding and payment. The breakdown of funds which the SFA agrees to pay the college is set out in Appendix 1. 6.2, college free to spend its funding as it sees fit, provided it fulfills the conditions of the funding. College should ensure the funds are not used for the purpose of delivering learning provision in respect of which the college has received funding, public or otherwise, unless the SFA so specifies. And in the event that the SFA identifies the college has used public funds in a way not specified, it may deduct. So again, you can't use this to fund other people. It's for funding certain categories of eligible students. 7.1, conditions of funding. The detailed requirements in respect of each learning program are set out in the funding rules as amended, which form part of the terms and conditions. 7.2, the maximum value of each learning program as shown may not be exceeded for any reason, unless it's been agreed and evidenced by a variation in writing. 7.4, the provision is to be delivered in accordance with any specific requirements. So remembering what the provision is, that's the education essentially for the students. The provision is to be delivered in accordance with any specific requirements of the SFA and delivery profiles and any tender documentation. And then 7.5, with the exception of European social funding, the SFA will restrict delivery of this financial memorandum against the funding available up to 31st March 16, whether delivery within this financial year fails to meet the minimum levels of performance or whether delivery in this period would result in the overall maximum value being exceeded, the SFA reserves the right to, in its absolute discretion, to vary the financial memorandum accordingly. And in terms of how the SFA operates that, just before we go there, 7.6, the SFA may allocate additional funds to the college under this financial memorandum. And then we go to, please, page 101, which is the operational performance management rules for SFA. And then we go forward, please, to page 109. And this explains in paragraph 11, we will use the information you provide in your funding claims to review your funding allocation. If we have evidence that you will not deliver a funding allocation or contract value in full, we may reduce that funding allocation or contract value to a level that is in line with your actual delivery. Again, this is tying it into actual delivery. If we go then back, please, to the SFA agreement. Just, I think, at 7.6 on page 54. Clause 8.1, submission of learner data. And then clause 9, subcontracted provision. Just interesting in terms of, you can see in 9.3, for example, the delivery provision under this memorandum. So what's the provision? It's the provision of education to the students may only be subcontracted to one level. Okay, this is all about the provision of education. And then, yes, I think I need to. 10.1 is a quality requirement. College shall deliver the provision to an acceptable standard, etc. I've already shown you the remittance advices for the SFA, showing that they got monthly payments. So we started with the test. What I said the test was, I've shown you the Upper Tribunal in my submission applying that test, applying it correctly, and I've shown you the agreements which in my submission eminently support the Upper Tribunal's approach. And so when we get to the question, well, where's the error of law, we respectfully submit there isn't one. But nevertheless, I'll move now, point 4, to dealing with the points Mr. Mantle seems to be relying upon. And the first is this concept of stipulating a price. And as I submitted yesterday, that's not the test. It doesn't supplant the test. If a price is expressly stipulated, that's helpful. If it's not stipulated, that doesn't mean there's no direct link. I've shown you a couple of cases on that already. If I may show you another one. This one is referred to in my skeleton as the EQ case. It's in your authorities bundle, please at 386.
Sorry.
Page 386, and it will be tab 23. The facts we can see beginning at paragraph 18 on page 390. So EQ has been a member of the Luxembourg Bar. Since 2004, he's been representing adults in his capacity as agent, curator, and guardianship manager. And the question is about VAT on the sums received for acting as guardianship manager. At 21, we can see, in addition, EQ submits that the position of the Luxembourg tax authorities is contrary to that of the Ministry of Justice, which bears the fees of the representatives responsible for the protection of adults when the latter are indigent, and which accepts the payments received in this respect are not subject to VAT. So you've got people that maybe lack capacity, and then EQ would act on their behalf. And what we're seeing here is that we're going to see in a moment that the court would, on a case-by-case basis, award sums of money for those services. And if the person was indigent, couldn't pay, then it would be the state that would step in and pay. So you did have potential third-party consideration in this case as well. The point at 23, the referring court explains that the needs of adults lacking legal capacity, that is to say, those affected by an impairment of their mental faculties as a result of illness, disability, or weakening due to age, are met by various protection schemes, including curatorship and guardianship, what makes it possible to provide advice, to supervise, and even to represent those persons in civil matters. The establishment of those protection schemes may give rise to the appointment of a special representative by the guardianship judge pending a decision on the protection regime. And then last sentence, in practice, curators, guardianship managers, special representatives, and ad hoc representatives are selected inter alia from family as well as from persons such as lawyers. And that's what EQ is. 24. The referring court states, first of all, as to whether the activities at issue constitute economic activities for consideration within the meaning of Article 2, the remuneration referred to in Article 3 of the regulation laying down the conditions for the appointment of the guardianship manager does involve financial consideration in connection with those activities. However, although the services provided in the present case are in every respect similar to an economic activity, the referring court is uncertain, first as to the scope of the finding in the case law of the court, that a supply of services is taxable only if there is a legal relationship between the person supplying the services and the recipient pursuant to which there is a reciprocal performance. In the protection of adults, there is a triangular relationship between the person supplying the services, the recipient, namely the adult protected, and the judicial authority entrusted the person supplying the services with a management role. It might also be relevant in this regard if the adult protected is indigent, the remuneration of the person supplying the services is borne by the state. Second, as to the amount of remuneration, although it follows from the case law of the court that it is irrelevant that an economic transaction is carried out at a price lower than cost, it would appear to follow also from the court case law that the remuneration must be determined in advance and cover the operating costs of the supplier. In the present case, the remuneration of the person supplying services is determined on a case-by-case basis by the competent court, depending on the recipient's wealth, with the result that the remuneration is not fixed in advance and does not necessarily ensure that the operating costs incurred by the supplier are covered in all circumstances. We don't need to look at the other questions referred which relate to economic activity and exemption. If we then move, please, to paragraph 37. In the present case, it is apparent from the explanations provided by the referring court that EQ actually received payments in the context that they exercised those powers of management and of representation entrusted to him. However, that court first notes that the performance of those services was entrusted to EQ not by their recipients, but by the competent authorities, in pursuance of legislation aimed at protecting them. 39. The court has already held that the fact that the activity in question consists in the performance of duties conferred and regulated by law in the public interest is irrelevant in determining whether that activity can be classified as a supply effective for consideration. 40. As regards the relevance in that context of the circumstance that in the event the recipient of the service is indigent, the remuneration for those services may be borne by the state. It should be recalled that it is not a requirement from the directive, as is also apparent from Article 73, for a supply of services to be deemed to be for consideration, the consideration for that supply must be obtained directly. See Ray under all. 41. As regards the procedures for fixing the remuneration for the supply of services such as those provided by EQ, it is apparent from the explanations provided by the referring court and from the written answers that the remuneration is fixed on the basis of a case-by-case assessment taking into account the financial situation of the person lacking legal capacity by the competent judicial authority at the request of the person supplying services, which must regularly report to that authority on his or her transactions. In addition, it is apparent that the remuneration is generally made up of a monthly lump sum in respect of the day-to-day management of the business of the person lacking legal capacity, and where appropriate, a sum in respect of additional services. 40. Perhaps I just ask you to read 42 to 45, please.
Thank you.
My submission in this case is firmly against, therefore, Mr. Mantle's proposition that a price needs to be stipulated in any sort of express or a priori basis. You don't need to know in advance exactly what remuneration you're going to get. The test instead is far looser than that, and it's satisfied if it's, according to this case, determined in advance and according to well-established criteria, such that it's foreseeable and capable of ensuring the person supplying services will in principle receive payment. So are the procedures established in advance, and are they capable of ensuring the person receives payment? And if so, then you've got enough to satisfy the full consideration test. You don't need a number in advance for a particular supply. And we saw that yesterday in the cases I showed you in the M&S case, where there was no price stipulated for the wine. That didn't stop it being for consideration. In Jemina L, we saw that the recipient of the asbestos removal services was told it was being provided with it for free from their perspective. They wouldn't have any idea what was being paid to the person actually performing the service. That didn't matter. And we also saw in a case where even if it looks like a price is being stipulated, as in the national car parking case, and you pay in excess of that amount, that can still be consideration. So this idea of, well, you have to stipulate a price, and if you don't, then can't be consideration, is with respect wrong. And if it was right, again, it would open the door to very easy avoidance. You would just not stipulate a price, and supposedly, therefore, you wouldn't have consideration. That's clearly not the law. There is an interesting example of just how complicated this can potentially get in the ING Intermediate Holdings case, which is in my supplemental authorities bundles, the first tab. And the question in that case was whether the provision of a deposit account to a customer was the consideration in circumstances where the bank said to the customer there were no fees for the deposit account. Well, like in Marks and Spencer's, the courts and the tribunal said actually there are fees or consideration, even if they're not expressed. And if we could go, please, straight to paragraph 45. If I could ask you to read, please, 45 through to 51, please.
Mm-hmm.
What we see, in particular starting at 45, is that the consideration there was the presumed reduction in the interest rate paid on the deposit accounts by the bank to the customer. You see there, the interest rate must in effect have contained some deduction. And the tribunals in court all held, well, that's sufficient to amount to consideration. No price was stipulated. It didn't say, well, we would have given you X interest rate, but we're giving you Y instead, and the difference is our price. There's no stipulation of any price at all. In fact, on the contrary, they said no fees, which the tribunal said, well, that means no express fees. So you don't need any express stipulation that this is the price that you're paying. Instead, the courts and tribunals will look at the arrangement to see what's really going on. And we see in particular at 50, and this is in relation to Mr. Pross's argument about not for consideration. There cannot be any argument in these circumstances but that the FTT, having found that there was a link between the making of the deposits and the banking service, the requirement for a direct link was also satisfied. Which again supports it being quite a general, wide test, which is what you would expect, given otherwise things will fall outside of the scope of VAT. It's very interesting because what it means is that the customer has essentially control over how much consideration is being provided over the course of the deposit account. The more they deposit, the more consideration they're providing. The less they deposit, the less consideration they're providing. But that didn't affect the existence of that link. And we can go on to see, because the Court of Appeal then goes on to ask, well, can this is a 52, can this consideration be expressed in monetary form? So non-monetary consideration has to be capable of being expressed in monetary form. And at 54, we can see Mr. Pross's case is that if there is consideration, it could not be expressed in monetary form. I reject that submission. The court would have to value what the depositor would, by implication, forewent in terms of interest rate in order to get the banking services. The courts are accustomed to finding the value of matters which have no ready market. It would be surprising if the courts could not find a monetary value in a situation which is essentially a financial transaction. And at 58 and 59, they note that in a similar case, but not the same case, the Court of Justice itself looked at the spread between foreign currency purchase and sale as giving the answer to, well, what is the value of this consideration? Accordingly, my submission on this point is that this simple notion that there must be a price stipulated is with respect, at the very least, an incomplete statement of the law, and probably wrong in terms of if it's meant to require some sort of express statement of a price. My fifth point, it is a point I develop in my Skirton argument. It's actually a point we've already seen in EQ. It's the point that the quantum and method of calculating the consideration are not relevant, save insofar as they indicate the payment is not for the suppliers in question. And I've referred to this already, so I'll take it as shortly as I can, but I think I can illustrate it by reference to some of the cases you've been shown already. So the first case is the PSA case. So we turn up our authorities bundle, please. Very last tab, page 450. We can see it, paragraph 6 to 8. In essence, we've got passenger transport being organised. 7. Paragraph 7. In the context of the proposed activity, P will be remunerated inter alia by the sale of tickets, the price of which will be determined by the organiser. If that financing method is not sufficient to cover the cost, the organiser will pay P compensation within the meaning of Article 50. 8. The contract concluded with the organiser will set out the arrangements for the payment of the compensation, the basis of which is the financial shortfall resulting from the activity, and will specify the maximum amount of compensation for a given period. So that's the point I made earlier, that the more passengers transported, so the more services provided, the smaller the compensation. So it's inverse.
I'm not sure that necessarily follows, and that if you had all passengers who devoted themselves 100% to the biggest loss-making route, it wouldn't have that effect. But certainly there may be scenarios in which more passengers means less subsidy. There may be scenarios when that's not the case.
Yes, okay. I can see that if there was a particular or some particular loss-making routes and everyone, yes, devoted themselves to that. Well, yes, fine. What we see though is the court itself at 456, page 456, paragraph 39. As the Advocate General observed, there was in that case a direct link between the healthcare services provided to the residents in the residential care home for the elderly and the financial consideration paid, determined on the basis of the care received and the number of residents concerned. In the present case, collective public transport services benefit not clearly identifiable individuals, but all potential passengers. In addition, the compensation is calculated without taking into account the identity and number of the users of the service supplied. Again, the point I'm making there is, well, there's not a link to actual use by any particular passenger. The same point about a lack of link with actual use is made in Bulgarska. Go please to page, begins on, it's tab 25, beginning on page 420. The relevant paragraphs are on page 46.
Paragraph 33.
30, if I can ask you to read 33, 34 and 37, please. So the point is the same one that the payment there on analysis was being made for some sort of generalized benefit of producing and broadcasting these programs, not for any specific supply to any particular individual. In contrast, as we saw yesterday in Rayon, it was linked to use, and that's the point that the court's been making in those other cases about Rayon. And we saw that, it's page 289. I did make this point yesterday, but if I could just show you again, because I do think this is right. During Mr. Mantle's submissions, it was suggested that at paragraph 18, the dependency level wasn't particularized, but I think, I did make this point yesterday, but I read it again last night, I'm sure of it now. When you read 18, it says, according to the statements of the referring court, the detailed rules for calculating the healthcare lump sum take into account 1, the number of residents hosted by each home, 2, and their dependency level, which are assessed in accordance with the conditions set out in certain articles, and I would say, you can insert 3 here, historical coefficients, which are determined at national level and updated each year on the basis of the average expenses. So there's 3 components at least there. 1 is number of residents. 2 is their dependency levels assessed in accordance with those rules. And 3rd is coefficients relating to average expenses. There's 3 different elements to that. And that's the point, is that this lump sum is being paid for those services to those particular individuals, which we say is in essence the same here. You've got a lump sum attributable to supplies to multiple individuals. I think finally on this 5th point is to show you briefly South Africa Tourist Board. If we could go please to page 62 in your authorities, which should be behind tab 6.
I'm sorry, which page?
Page 62, my lady.
Thank you very much.
And we see at paragraph 3, South Africa Tourist Board carries on a number of activities in pursuit of its objective to promote South African tourism. To a large extent, it is funded by the South African government. It was that relationship governed by an agreement between SATB and the government that gave rise to the dispute in this appeal. And so I make this point now, but there was no possible third-party consideration scenario. There's not individuals receiving some benefit.
It's a two-party case.
It's a two-party case. There's no specific individuals benefiting from marketing. You can say, well, the South African government's paying for you to benefit from it. It's just a two-party case. And the Upper Tribunal concludes, in agreement with the FTC, that there was no supply to the South African government. And frankly, that's the same here. We're not. Nobody's saying there's a supply to the funding bodies here. So actually, how far does this take us? Not very far. You can see that at paragraphs 64 and 69. So my respectful submission, this case cannot tell you very much about a case where the funding is being provided in some way to pay for specific education for specific individuals. It just doesn't raise that issue. It's simply considering, can we say you're making a supply to the South African government? Answer no. Well, if you translate that to our situation, it would simply tell you there's no supply to the funding bodies, which no one's arguing for anyway. Sixth proposition, again, I did deal with this yesterday. I'm not going to repeat what I said yesterday, but it's the fact that the single sum is paid for multiple supplies does not affect the for consideration. I've made that point by reference to M&S yesterday. I don't propose to show you that again. I've made it also by reference to Ray under all, which again we say is a lump sum payable for multiple supplies to multiple individuals, irrespective of how you characterize the supplies. Doesn't matter. Still multiple supplies to multiple individuals. But there is one case I'd like to add to what I showed you yesterday, which is KE Entertainments. That's in your bundle behind tab 10, beginning at page 161. Have at paragraphs 2 to 4 a very brief description of the taxpayer's operations. So we see in paragraph 2, a customer who wishes to play bingo pays a fee which entitles the customer to take part in a number of games of bingo forming a session. On payment of the fee, the customer receives a book of cards. The customer does not need to participate in every game. Cash prizes are paid to those who participate and win. Paragraph 4, this is important. The bingo club manager decides after the sale of tickets for a particular session, a particular session is concluded, and immediately before the session begins, what the prize money for each game in the session will be. Say that some games, typically the jackpot game, are played for fixed prizes advertised in advance. Such prizes tend to be consistent for the same sessions from week to week. Why is that important? It's important because at the time the customer pays the sum to participate in a session, it is not going to be known how much money is going to be spent on prizes for that session. That's what it's saying, that the manager decides once they've seen how many people have signed up and taking into account whatever factors they want, they decide what's going to be the prizes. Why is that relevant? Because as we'll see, the whole point of this case is about the apportionment of the money paid between consideration for the supply of bingo services and the stake that produces prizes. So the bigger the stake, the smaller the consideration. And which means that you cannot say, when person number 1 signs up for a session of bingo, you will not be able to say at that time what proportion of the money they are handing over is going to be treated as consideration. It's going to depend, logically, on how many other people sign up to play in that particular session, and then the bingo manager's discretion as to how much he or she is going to allocate to prizes. Which means that even if you wanted to, even if you sat down and said, we must work out a price at the time of signing up for the session of bingo, you wouldn't be able to. But that doesn't stop it being consideration. If we go forward then, please, to paragraph 9. I just ask you to read 9 and 11, please, which talk about splitting the payment into 2 components. I hope that confirms what I was saying a moment ago, that the consideration for the supply is not the total amount paid over, it's going to be some sum less than that. How much depends on this apportionment. The reason for the appeal was because HMRC had changed from applying a game-by-game basis to decide how you apportion the sum paid between consideration and stake to a session-by-session basis. We see that, that's in paragraph 12. And in terms of how the apportionment should be conducted, we can look, please, at 31 and 32. In essence, there is one method of correctly apportioning it. You've just got to work out what it is. In that case, it was session by session. The relevance of that case to our case is, insofar as I've said, it shows that you can have a scenario where the amount of consideration provided will depend on factors that arise after the agreement for the supply of the service has been entered into. Because that's what was happening there. A person enters the bingo, other people enter later. That's going to affect how much of the price, the money paid, is consideration or stake, as will the bingo manager's discretion. Now, it's not a group supply case, but it's, if I can call it a quasi-group supply, because the amount of consideration I'm paying for the supply of service will depend on what other people decide to do. But it simply shows that the idea that it confirms that you can apportion, and you can make that apportionment even later than the time that the supplies have been offered and accepted. And that doesn't break the direct link. So I combine that with what I said yesterday in my submission. It's not right to say that where you have a single sum paid for multiple supplies, whether that be multiple supplies to multiple individuals or to the same individual, that somehow breaks the direct link. It would be very surprising if it did. Unless the court has any questions on my first 6 points, I turn to my final point. And this is the vexed issue of Kenema supplies. And our respectful submission is that this area is actually irrelevant and a red herring. I've shown you in the relevant paragraph, Upper Tribunal 2020, and by extension these tribunals applying the correct test for direct link and reaching what we say is the correct answer. There is, in my submission, not a great deal of utility in debating, therefore, whether we could place this case in one particular pigeonhole called Kenema or Rayon or Saudercore rather than another.
But humorous in that regard. Do you say the Upper Tribunal were right to say that there was no Kenema element in Rayon d'Or? And were they right to say that Rayon d'Or itself dictated, as it were, the outcome of this case?
The short answer is I'm actually going to go through it in a little in a little bit, because that said, I can't ignore what's been said. First point, HMRC agree that the Upper Tribunal is correct to say that Rayon was not a Kenema case now, in the sense that it was not merely granting access to a facility. We do have that reference to permanent availability. I'm going to come back to that in a moment. In terms of what Rayon, Kenema, and Saudercore are relevant for, well, we say they're relevant for what they tell us about what will satisfy the direct link test. They don't tell us much, if anything, about what will not satisfy the test. Because in each of those cases, the court says, well, the test is satisfied, and it refers to various reasons why it is satisfied. It doesn't tell us that in other cases without those features, it won't be satisfied. That's an extension that doesn't follow. You've already heard my submission that Rayon does provide the answer to this case, because Rayon was exactly considering a lump sum for supplies to multiple individuals. And in my submission, I make this point in my skeleton, which I think answers my Lord's question. Rayon, there was both availability and actual services. And my reading of the case is the court says the consideration is for both. So if we do turn up Rayon just to see that, it's 292. Paragraph 32, which then leads into the reasons. But the starting point is it's clear the healthcare lump sum at issue in the main proceedings is paid to the RCHEs and is received by the latter as consideration for the care which they provide in different forms to their residents. I mean, that, on HMRC's analysis, it's paid solely in consideration for some sort of availability supply, which wouldn't be care in different forms. Query whether it's even care at all. Standing ready to provide something is not, I would say, the same as actually providing it. And in fact, if you look at the disposition of the answer on paragraph 39, it talks about, so this is by C on page 293, healthcare lump sum at issue in the main proceeding constitutes the consideration for the healthcare provided. So in my submission, the court's saying it is consideration for the healthcare you provide in different forms. And even at 36, which Mr. Mantle elevates to some sort of supervening principle that answers a lot of the questions in this case, even there it says inter alia by the permanent availability. So availability was a component of it. Actual provision services was another component. But I'm not really sure, and this is where I've always struggled, as to why that dispute really helps us in this case.
Well, it might be said that one needs to read 36 and 37 together, and the two paragraphs taken together are an answer to the arguments being presented by Rayon d'Or, because they were saying, well, this is not for consideration because it's not defined in advance, it's not personalised, and it's a lump sum, to which the court's answer is, well, none of those three things matters.
Yes. Yes. And in any event, you don't have that problem in this case because you do have specific supplies to specific individuals. It's not a case of what additional things may happen to be provided over the course of the year that weren't contemplated or within the original provision. You've got specific supplies of education to identified individuals, and so that point doesn't even arise. In terms of what the Upper Tribunal in 2020 said about this, if we could turn please to your authorities bundle, 200. And at 71, the Upper Tribunal says, we do not understand the reference of paragraph 36 to services which are permanently available to be a characterization of supplies as Kenema supplies, as distinct from any other type of supply for that purposes. Rather, we understand that those words to describe the services at issue in Rayon, namely a service provided year on year by the RCHEs to their residents, whoever they may be, from time to time on a rolling basis. And, well, that to my ear sounds right, and the important point there is that whoever they may be, to their residents, whoever they may be, from time to time, because that answers you need to know exactly who's going to be receiving what supply at what time, and then some sort of lump sum apportionment. No, Rayon was about actually even looser connections, because the residents, whoever they may be. The court's conclusion, reading on, was that the healthcare lump sum, which was not personalised to any specific supply of healthcare to any particular resident, was still consideration for that purposes. Kenema supported that conclusion because Kenema shows that reciprocity can still exist, even though the payment in question cannot be related to each personal use. See nothing to disagree with in that. At 72, this is all conventional VAT wisdom. It would be surprising to us if the court had held a different rule should apply just because a transaction happens to fit the Kenema model, as HMRC suggests. The better analysis is surely that the rules for identifying what is or is not consideration for VAT supply are generic, developed in the case law of the European Court, which rules fall to be applied in the infinite variety of different circumstances. Kenema was just one case on one set of facts. It is an illustration of rules to be applied. Again, I mean, that's just right. And it's really going back to, there's one test here, it's the direct link test. Kenema illustrates the court applying that in relation to a particular type of supply. And that may or may not be helpful in showing it a direct link in other cases, but really it doesn't take us very far. But what is important, what we say is the relevant point you get from Rayon d'Or, is the point observed in 71, that there the court said, well, there's consideration for these supplies of services even though they're just simply to the residents, whoever they may be. And that's right, as we discussed yesterday, or as submitted yesterday, as Mr. Mantle seems to accept, the identity of residents can change throughout the year. And there's no suggestion that because Mr. or Mrs. X turns up in March of the year, their supply is not being for consideration because the lump sum was agreed last December or paid last December when they weren't even in contemplation. And so it does help on that point. At 73, Rayon is not a case involving a Kenema supply at all. I think Mr. Mantle agrees now.
Well, I don't think he agrees with that in perhaps quite the sense in which the tribunal made the statement.
Yes, he accepts it's not the same in terms of a right of access as compared to standing ready to provide actual services with actual services being provided. But Mr. Mantle wants that qualification, fine, it doesn't really take me anywhere. And similarly, Saudacor again, as was pointed out, yes, is a different type of supply again, because there you've got not permanent availability to supply, it's the permanent continuous supply of management and administrative services. And that's why I started with the point, in my submission, it's not helpful to try and pigeonhole a case into one of these categories. But there are no such categories. You have the test, and you have illustrations of the application of the test, and what is said in those cases may be more or less helpful, depending on your own facts. But you cannot reason that, well, because in Rayon the court said these features don't exclude a direct link, then
well,
other cases...
In essence, what we have in these cases is a series of dismissals of factors that are relied on as negativing supply for consideration. So in Kenema, the argument was, well, it's just a right of access, to which the court says, doesn't matter, it's still supply for consideration. And then when you get to Rayon, it's a similar process of reasoning, which is the argument is put forward, it's just a lump sum, it's not personalised, etc. And the court says, again, it doesn't matter. So it's a process of rejection of reasons that are being advanced for saying this is not a supply for consideration.
Yes. Which then begs the question, well, what in this case do HMRC say is the fact that the negatives the direct connection here? Well, I've dealt with the points I can identify, and we say neither is a good point. And frankly, neither of them is supported by the cases relied upon. We do have some cases, that's PSA and Bulgarsko, where the court did say no direct connection with a particular supply. I've shown you those, and the reason was, well, because there was absolutely no connection there between the payment and any actual supply to an individual. But that's not our case. I think even Mr. Mantle accepts that. And so we are left in the situation of saying, well, the tribunal's applied the right test, it's reached a conclusion that seems plainly sustainable. Is there some point of law, some point of factor that as a matter of law negatives that conclusion? And if so, what's the authority for it? And in my submission, HMRC haven't identified any. Unless the court has any further questions, those are submissions for the respondent.
Thank you very much. You're sure you've had sufficient opportunity to say what you want to say?
Absolutely, my lady, yes.
Thank you. Mr. Mantle.
My lady, my lords, I'm going to reply on some of the cases my own friend has taken to yesterday and this morning. On the Wakefield Court of Appeal case, those instructing me are keen to emphasise that a key message that was coming from the Court of Appeal in the Wakefield case was that there were two different questions which had to be examined. One was, is the supply for consideration in PVD terms an Article 2 question, and the other is the supply part of economic activity, an Article 9 PVD question. And it's important to recognise them as distinct, and that each test requires something different. That's important because yesterday and today, my learned friend has prayed in aid Wakefield to suggest that there are direct link tests of different stringency, and that it's relatively hard to satisfy the direct link test relating to economic activity as he sees it, and easier to satisfy the direct link test in relation to consideration. Of course, as you've seen from very many authorities, the direct link test, reciprocity, and the need for a legal relationship are key to consideration. There was suggestion from the bench, there was a suggestion to the Court of Appeal from counsel in the Wakefield case that it was helpful to look at Article 9, economic activity, in terms of a direct link or a sufficiently direct link. In a paragraph that my only friend took you to, it's paragraph 58 on page 119, so I don't need to take you there again, unless you would like me to. The court positively moved away from the use of the concept of link or direct link or sufficient link in the Article 9 context. It described it as confusing. Lord Justice David Richards, as he then was, described it as confusing shorthand for the Article 9 broad inquiry whether a supply is made for the purposes of obtaining income being words found in Article 9. So we submit it's important that this court doesn't fall back, contrary to what was said in that case, sort of analogizing the economic activity test and the consideration test. And just to emphasize, although paragraph 52, to which you were taken this morning, is we submit a good but brief summary on the direct link test, the Court of Appeal, for consideration, the Court of Appeal didn't explore that test in Wakefield at that point or later, because there was no issue on consideration in the case. And I don't think you were taken to it. I don't think it's necessary to take you to it, but for your note, that's made explicit on page 122 of paragraph 74. Turning to the Jamina Al Court of Justice case, the decisive point in that case, as my learned friend pointed out,
I'm sorry, I'm very slightly behind you. Jamina Al, yes.
Jamina Al, another supplementary
Yes.
authority. The decisive point in that case, as my learned friend pointed out, was that the Court of Justice concluded that the relevant activity in relation to asbestos removal carried on by the local authority, it was not an economic activity. However, before getting to that point, it did in paragraphs that my learned friend showed you at Supplementary Authority 60, paragraphs 39 to 40, and again, I hope I don't need to take you there, it did deal with consideration. And it concluded that there were two supplies. One was an utterly straightforward supply. It was a supply of asbestos removal by a company specialising in asbestos removal, supplied to the local authority, and the consideration was plain because the local authority paid the contractor in return for that service. And then the Court of Justice contemplated a second supply by the local authority to householders of asbestos removal, but that supply being funded by a grant from the Environmental Protection Agency paid to the local authority. And the Court of Justice left it for the referring court to determine the point on the facts, as whether there had been such a second supply for consideration, and actually the referring court would never needed to do because it was told that there was no economic activity going on. But the service supplied the judgment of the CJU records by the local authority only on condition that the local authority received grant funding, and grant funding was only paid on the basis that the local authority carried out, in fact, the decision says, completed services of asbestos removal. And obviously it did that by employing its specialist asbestos contractor. But that's just, in our submission, a straightforward case where it's very clear that the funding is paid in return for a particular supply by a local authority to a particular resident of removing asbestos from that resident's premises. So we say Jamina L is of no help here. The third case, which my learned friend referred to yesterday, is the Court of Justice Zhlakov case, which is in the Supplementary Authorities Bundle at 63 for your note. Now, you may recall that this involved the contract between a lawyer and his client, and that provided that the supply of services by the lawyer to the recipient of the supply was free of charge. And the court held that the fact that in that agreement there'd been a stipulation that the supply was free of charge and the customer wouldn't pay, did not have the fact of preventing that from being consideration. But we've not contended before this court or earlier that because the supply is made free of charge to the recipient, in this case the students, and is said to be made free of charge to the students, that means that there cannot be third-party consideration, which is sufficient consideration for VAT purposes. So that doesn't advance matters. And the Court of Justice found in the combination of the agreement between the client and the lawyer and legislation requiring payment of costs by an unsuccessful opposing party, both the legal relationship and the reciprocity between the payment from the losing party and the supply of the legal services to the successful party that was necessary for the direct link, and the amount of that fee that had to be paid by the losing party was again fixed by a specific scheme of legislation. And reference was made in paragraph 24 as well, which we submit is clearly not an attempt to define the only circumstances in which a direct link could be broken. It addressed the circumstances in which a direct link could be broken that were relevant to that particular case. And I say could be broken, I think it was submitted could be broken, and the Court of Appeal recognised, sorry, the Court of Justice recognised that they didn't apply on the facts of the main proceedings. Now, I'm next going to deal with the Monks and Spencers case. And in that case, we submit that there was a stipulated price, very straightforwardly agreed between the supplier and the recipient of the supply. A price of £10 agreed at the till. And the question before the court, sorry, the tribunal, I think, is whether that price was agreed for 4 items or only for 3 items. And the findings that the customer had to pay £10 at the till to get the wine and the other 3 items. And in our submission, it is clear in that scenario what is paid and what is paid in return for. And as was pointed out in the decision, the economic reality was that the consideration was for a package of 4 items. So in our submission, that clearly is a good example of the well-known scenario where in a transaction between one supplier and one recipient of supply, a single price is agreed for a number of goods and services. And in that case, it was clear what the price was for, the stipulated price was for, and there could be no question of there not being a direct link between the 4 items and the price, and that raised a particular need for an apportionment in those services. But the apportionment of the price was not in any way being used by the court as a way of establishing the necessary direct link between the goods and the payment, the stipulated price. And it really has no parallels, we say, with the situation that is before you in this appeal. And my learned friend made reference to the reference in the Marks and Spencers case to the decision of the Court of Appeal in the National Car Parks NCP case. And his submission at the end of it was that in this case you could see different prices for the same supply, and it seemed to be suggested that that could be meaningful and have relevance to the case that you're concerned with. However, as I think is sufficiently clear from the report of Marks and Spencers, and is certainly clear from the report of National Car Parks in the Court of Appeal itself, the Court of Appeal took the view that the consideration for VAT purposes, although it wasn't the same as contractual consideration in English law, in the circumstances of that case, the consideration for VAT purposes couldn't be lower than the contractual consideration. And it took two possible scenarios where the charge for parking for a particular time was £1.40 and a customer had the right change, £1.40, in a situation where the customer only had £1.50. And it concluded that where the customer paid £1.40, the agreed contractual price is £1.40, and where the customer paid £1.50, the contractual price is £1.50. That's simply an example of there being different prices agreed by one supplier as a matter of contract between different recipients of the supply. It doesn't assist at all in our submission. If I could go on and deal with the Ing case, in our submission, that also doesn't assist your ladyship and your lordships in deciding this case. It came out in my learned friend's description of the case, although he put it differently at one point. Ing is a barter transaction. There's, on the one hand, the provision of banking services by Ing, and the other side of the barter is the depositing of the money in an Ing account, an Ing deposit account, by the customer. So it's that depositing of the money which is the consideration for the banking services. That depositing of the money is not monetary consideration, it's non-monetary consideration, hence the reference to barter. So the consideration is known. It is the non-monetary consideration of depositing of money. My learned friend's right that the amount of money deposited may change, but that in our submission isn't of any significance to the analysis. And in that case or here, my learned friend also referred you to passages in the judgment which dealt with the need to be able to put non-monetary consideration in monetary terms. That's a requirement for non-monetary consideration to be acceptable in terms of consideration for VAT purposes. But the issue of how you go about ascertaining what the money value of non-monetary consideration is, and whether you can, it is totally separate from any question which arises before you. Simply to add that it's unsurprising that where a tax authority or a court has identified non-monetary consideration, it will strive to find a way to attach a monetary value to it. But in our submission, Ing provides no real help. And KE Entertainment, we'd say what's important to bear in mind first in the case of KE Entertainment is that although there will be a number of consumers participating in a session of gambling in a bingo hall, the transaction that was an issue there and needs to be looked at is a simple supply of services by a gambling operator bingo provider to a single customer. And in our submission, in that context, it's clear that the consideration is defined at the beginning of the process. My honest friend's right, you can't put a monetary figure on it at the beginning of the process, but it will readily become ascertainable.
Do you mean the criteria by which it will be defined are known at the start of the process, but
they are?
The application of those criteria may vary depending upon the number of people who participate in a particular game and the manager's decision as to how much.
Yes, what it will really vary on is what the amount of the stake is. Sorry, I beg your pardon, that's quite wrong. What the amount of the prize is in each of the games in the session, and that may be decided after a ticket has been sold. So after a contract has been made between the bingo player and the bingo provider. But there always will be a prize in each of the games, and once that's been ascertained, one can calculate what the consideration is. But although one doesn't know precisely what the stake is before, or perhaps not until long before the session has started, one always knows that the consideration will be the payment made by the customer less the stake. So again, that's very different circumstances from here. Sometimes gambling cases can be helpful and do contain some wider principle in relation to the operation of the VAT system or issues like consideration. But gambling cases very much turn on matters that are specific to gambling and the difficulties of taxing it. And that case in our submission doesn't provide you with any assistance. So coming to my learned friend's 7 points, we submit that the key in relation to the test, which I'm going to refer to as the direct link test, has 2 parts. One, legal relationship, with which we're not concerned in this case. Legal relationship is not disputed by my clients. We've made points, as your Lordship mentioned this morning, as to the lack of a legal relationship between students and funding agencies being part of the context and of some significance, because there's no obligation on the funding agencies to fund particular or any students' education. But the key point is of reciprocity. And in answer to a point that my...
So, in other words, you agree with Mr. Firth that the test is reciprocity? Leaving aside legal relationship, which is not an issue.
Yes. If I put it this way on the test, the requirement is reciprocity. But it has to be reciprocity between the consideration, the payment, and between a particular supply of a service, the particular conferring of a benefit. And that's where we say, in essence, that the Upper Tribunal 2020 erred in law because it didn't look with the right degree of specificity. And you can see that it was concerned in the paragraphs my learned friend took you to and I did, to show you how it decided the case in the alternative. It was wrong about Rayon or being conclusive. And that it did have some appreciation of the need for a sufficiently specific reciprocity between supply and service. But in our submission, it proceeded on two generalised a basis. And just in response to what my learned friend said, and the suggestion that the Upper Tribunal had the right test, in our submission, it's far too low a degree of scrutiny by an appellate tribunal or court to simply say, well, the tribunal noted the words of, say, the Tolsma case, and saw a reference to direct link and saw a reference to legal relationship and reciprocity, and therefore it cannot have made an error of law in relation to the test. And in our submission, and I am repeating a submission in reply here that I've made earlier, it is the level of generality at which the tribunal was looking, which was incorrect in law. And we just reiterate very quickly that the points we've made, and I'll come on to points my learned friend has made about that, about further education colleges having choice about the number of students that it enrolls, the courses that it offers for students to choose and accept, the number of contact hours, and the like. And in our submission, much more careful consideration is needed in a case such as the case you're examining here, where you do not have a simple supply by a supplier to a single recipient, and that recipient providing consideration in return, but where the question you're testing is whether a payment by a third party is sufficiently reciprocal to the activities which are being undertaken by the service provider. And we say that those features are important here. It's also important, which is a distinction from the Rayon case. We say that in the Rayon case, the same service is being provided to each resident, characterised, we say, purposefully by the Court of Justice as being permanently available to provide healthcare services, and that isn't the case in relation to these actual provisions of different courses with different...
well, on that point, could you help us with your answer to the point to which Mr. Firth drew our attention, which certainly had escaped my attention up until that point, which is that, of course, from the perspective of the Court of Justice, the key part of the judgment is the dispositif, because it is the dispositif which is that which is binding upon the referring court when it comes back. So when we look in the dispositif in Rayon, what we find is the court says that the legislation must be interpreted as meaning that a lump sum payment, such as the healthcare lump sum at issue in the main proceedings, constitutes the consideration for the healthcare provided for consideration by a residential care home for the elderly to its residents. and on that basis falls within the scope of value-added tax. So in the dispositif, what is identified as the supply is the healthcare provided to the residents, not mere availability. What do you say to that?
And my lord, the court has used that term consistently earlier in its judgment before paragraph 36 to describe the services which are being provided. But that's a description of the services, whereas the key VAT characterization of the services is what one finds not in the dispositif, but in paragraph 36. And the dispositif has to be succinct. And I accept that it wouldn't have been very much longer if it had referred to permanent availability, but it would have been longer. What's said in paragraph 36 in our submission is not oblique, it's very clear about characterization. I can't gainsay the point that the tribunal, sorry, the court is making a point in paragraph 36, which is leading on to its conclusion and the dispositif that there is a supply for consideration. But you already have my submissions, I think, on why it would be hard to understand the trouble that's been taken on characterization in paragraph 36.
Right, then let me ask the next question, is what do you say to the point that when we look in paragraph 37, again, the supply is characterized in the same way, quote, the healthcare provided to residents. And what the court is doing is saying that three things do not matter, do not detract from it being a supply for consideration. Firstly, it doesn't matter that it's not defined in advance. Secondly, it doesn't matter that it's not personalised. Thirdly, it doesn't matter that it's payment in the form of a lump sum.
Yes, but that's undoubtedly right. In our submission, it's given a reason why that does not matter. And that's because the supply can be characterised in the way that is, or must be characterised in the way that's described in paragraph 36. And that becomes the key characterisation. I don't think the court is denying there, as can be seen from paragraph 36 in the dispositif, that you can also describe the services as healthcare services. But the key characteristic, which leads to that conclusion in paragraph 37, is that we say that you have to characterise the supply in that way. And once you have characterised it in that way, then those negative reasons, which otherwise would have had force, don't apply in the circumstances before the court.
Thank you.
If you just bear with me one moment. Yes, and so that's all I need to say, or all I intend to say in reply on my learned friend's first point. On the second point, I've already addressed you on the relevant paragraphs and why we say the Upper Tribunal 2020 fell into error. And so unless there's anything specific you wanted me to say on that, I was going to move on to my learned friend's third point. And he's taken you in considerably more detail than I did to the funding agreements. And in our submission, the key is reciprocity between the funding amount, or between the funding payment that was paid by the EFA and by the SFA to the college, and as I submitted, specific supplies of services to students. And I've suggested features on which we rely to say that direct link cannot be made. And we would characterise the agreements, indeed we already have, as conditions of funding. And the fact that the agreements require provision of educational services to categories of students who are entitled to that provision for free, in our submission, does not create the necessary reciprocity. And all of the conditions that my learned friend took you to, and the associated documents in our submission are entirely consistent with a funding body, funding an activity, rather than purchasing particular supplies of services, but imposing conditions to ensure that public money is efficiently and properly spent for its intended purposes. I do accept that there are provisions in the agreements which, particularly the EFA agreements, which can deal with extreme circumstances. But in our submission, those are not the most helpful clauses and provisions in addressing the issue before you. In relation to the EFA, we say that given the choices that CIC has, it is significant that there is no generally applicable provision relating to under-delivery and over-delivery. Indeed, in our submission, under-delivery and over-delivery are not concepts which really sit well with the nature of the agreement. Money is being provided to be properly spent in fairly broadly defined areas, and I've said that it cannot be veered away outside those areas. But the lack of the ability to adjust the amount of funding, contrary to my learned friend's submission, we say is important, because that's consistent with an organisation being funded for an activity. It's not really consistent with particular supplies of services being purchased, and it does not fit with there being a direct link between the funding amounts and the sums which are and the benefits that are received by individual students in respect of individual supplies of education. But I fear I've begun already repeating myself, which is not the point of a reply. The fourth point that my learned friend made was on stipulation of price. if my learned friend submits that that's dispensable, stipulation price or consideration, then that simply doesn't fit with authority in the Court of Justice, in particular the Chesky Rojas case, but also the Tosma case, for example. So the question is what stipulation of price means. And in our submission, I think, as you would have appreciated, don't go too far as to say that a price must be fixed in advance for each supply, which is calculated and expressed in pounds and pence.
Would you accept that it's sufficient, to use the words of the Court of Justice, the amount is determined in advance on the basis of well-established criteria?
Those are the words that the Court of Justice uses
Repeatedly,
and therefore, cutting to the chase as your lordship has, that is the best description of what is required.
In advance, but having to embrace the KE entertainment, that while the formula will be known in advance, the particular value of inputs may not.
That's correct, and there is a mechanism, and as we've seen, the mechanism may be applying some legislation to determine what the price for a lawyer's fees are after the event, but the mechanism, the legislation is there, and that mechanism, I don't think one goes so far as to say that it couldn't have some sort of discretionary or human element in it, but the mechanism has to be there. And here we say that there isn't a mechanism, there's simply a lump sum. And a formula which does take account of matters that are relevant to the provision of services of education has certain additional factors added in for CIC and more for certain other colleges, and simply we say can't be directly linked to particular supplies of services to students. Again, the court has made some points to me about rayon d'or, and I've made points back. I don't accept my learned friend's characterisation of how the dependency amount is arrived at. At the end, I don't think I can say much more. That's going to be a matter for you if you think it's significant for the case. But I'd submit that the right reading is that one takes the actual number of residents in the home, one then applies a dependency factor which is based on national criteria. It's hard to know to be sure, but in our submission that's the better reading, and that does lead you in the case of rayon d'or to simply have a per resident price. We submit can be seen, and it's important in that, as I submitted, we say that the court characterised the service as a service of being permanently available, and that's the same service being given to each resident, although it may be drawn on differently. And it seems in practice it must be right that the number of residents could vary at least for a time over the course of the funding period. But in our our submission, that doesn't mean rayon door is analogous with the position here, and the degree of choice which the college has, the Colchester has, in relation to the matters which I referred you to earlier in my reply. In our submission, short as it is, the EQ case doesn't really take matters significantly further. And I've already dealt with Ing. My learned friend says that quantum is not relevant unless unless it helps you identify that the consideration in issue is actually in return for a supply. The point I want to make is rather the reverse of that, but related to it, which is that where you have a lump sum payment, the quantum of the lump sum payment is known. And in some circumstances it can vary, as you've seen from the agreements. In other circumstances it will remain the same throughout the academic year, no matter how many students are actually provided with education by the college. But in our submission, you can't say that because you have a lump sum payment and quantum isn't important, there must be the necessary specific reciprocity between a lump sum payment and individual supplies and benefits that are provided to students in circumstances such as those of this case. Unless you want to hear from me further on South African Tourist Board, I wouldn't intend to go back to South African Tourist Board. Save to say this, which is, in our submission, it's unfair to the breadth of the thoughtfulness and consideration that Mrs. Justice Rose, actually then one, was giving to the question to say South African Tourist Board is just a case of grant funding where the only contentions were that there was going to be consideration from the funder for a supply to the funder. In our submission, she does look more widely at the applicable principles. And I think in relation to a single sum, I've addressed you sufficiently on what I said on paying entertainments and Marks and Spencers, and what I said about distinctions we contend for between this case and rayon door. Just bear with me a moment. And I feel that I must have said enough about Panama supplies and
permanently available if you want to say.
I don't need to say. I don't feel I can contribute anything more usefully, despite having listened carefully to what my learned friends said.
Thank you very much indeed, Mr. Mantle. And thank you to everyone, both those who have addressed us and those who have no doubt worked extremely hard on this case behind them. This interesting and difficult case, it won't be surprising to you that we will reserve our judgments, and they will be dealt with in the usual way, which I'm sure you're all very well aware of. Drafts will be sent out as subject to the embargo, which we take extremely seriously and we remind you about. We'd be grateful if you would correct our spelling and our grammar, but not our reasoning. And we would also be grateful if you were able to agree a consequential order. If you are not able to do so, please provide us with very short written submissions about your differences. Thank you very much indeed.
All rise.